First, if Democrats take back the Senate, they need to seriously consider being willing to eliminate the legislative filibuster in order to get things done if Republicans continue to obstruct reflexively as we've seen them do in the past. And second, we'll need to meaningfully reform the Supreme Court. Because even in the most optimistic of scenarios, where Democrats keep the House, take back the White House, retake the Senate, and are willing to get rid of the filibuster, any new laws from the day of enactment will be vulnerable before this deeply politicized court. Long before now Justice Kavanaugh vowed revenge on his political enemies at his confirmation hearing, the Roberts Court has already proven its willingness to act in a partisan manner on issue after issue. On voter suppression, the Roberts Court has shown its willingness to act politically by gutting the Voting Rights Act. On campaign finance, the Roberts Court has shown its willingness to act politically with the Citizens United decision. On gerrymandering, the Roberts Court has repeatedly looked the other way in the face of the most nakedly partisan redistricting schemes. And so even if Democrats in 2021 enact reforms in any of these areas, the Roberts Court, it should be assumed, will act in a partisan manner yet again and hollow out any such reforms. When it comes to economic plans that a future Democratic president may sign into law in 2021, we face the same problem. Medicare for all, a $15 minimum wage, combating climate change, seeking to ban forced arbitration. None of these proposals would be safe before the Roberts Court. Indeed, the Supreme Court nominees of the past two Republican presidents have been handpicked specifically with the purpose of ensuring their hostility to these types of proposals. Progressives cannot surrender to this conservative brand of judicial activism. We can't resign ourselves to spending the next 40 years living under a judicial oligarchy installed by the Federalist Society. We need reform of the third branch of government. We must look at ideas like expanding the number of justices on the court to ensure a future Democratic president might have the chance to fill 2 or more seats. We need to look at the idea of ending life tenure for Supreme Court justices in favor of term limits that would guarantee each president in the future the chance to nominate a fixed number of justices in any given 4-year presidential term. We'll hear about some of these and other proposals in the course of tonight's program. There may be disagreement about exactly which types of court reform make the most sense, but doing nothing is clearly not an option. So as Democrats running for president begin to position themselves and lay out their ideas, they must incorporate some version of reform of the court into their plans. That needs to be part of the conversation, and that conversation is intended to begin this evening. And our organization, Demand Justice, will commit itself to taking a lead role in seeking to ensure this remains part of the conversation and that the enthusiasm that we saw in the backlash and opposition to the Kavanaugh nomination does not dissipate and that his seat on the court does not become a normalized thing, because it isn't. With that, I'd like to kick off our program formally by introducing our first speaker, a true leader in our movement, somebody who, before assuming his current very important role, was known to all of you as a champion for working families as the Secretary of Labor in the Obama administration, and before that was at the tip of the spear in fighting the good fight against voter suppression and discrimination across the board as the Assistant Attorney General for Civil Rights in the Obama Justice Department. Please join me in welcoming Tom Perez.
I come with gifts for a certain friend of mine, Brian Fallon. Brian and his wife, when she was at the White House, gave birth to twins, and now they just had a third child, and I wanted to make sure we brought you a little gift. So it's a Democratic onesie. Why can't we start early? Because I know the two of them are good Democrats. So. Thanks, buddy. It's great to see you. Hey, thank you. Thanks for having me, Brian, and thank you for your leadership. This is a gathering I can see from looking around of serial activists. And I'm looking around at people like Bob Kramer. Bob Kramer was one of a number of reasons why I was the first cabinet secretary confirmed on a straight party line vote in American history, because we did edgy stuff. We were trying to build an America that worked for everyone. And we were doing so in the context of a Republican Congress that was hostile to things like enforcing the Voting Rights Act, enforcing laws against police misconduct, enforcing predatory lending laws. And so Bob and others in this room, thank you for what you're doing. and what you continue to do. And thank you for shining a light on an issue that is all too frequently under-discussed in the progressive ecosystem. We have 3 branches of government, and we haven't paid enough attention to the need to understand that. I was a Pell Grant kid in college, and one of my summer jobs at night, because I used to play baseball, was I was an umpire. And I get really angry when I hear John Roberts say he's an umpire. That's disrespectful to every umpire across America, because we did call balls and strikes. And so please stop analogizing yourself to an umpire when you're not. Because, and I say that, only half kiddingly, but folks, this is serious business. And what I am not going to do tonight, because there is a panel of remarkable experts here to do it, is get into the critical minutia of where we go from here. Both the theory and the tactics, reform proposals, what we need to do. I looked at the outline of what you're doing, and I said to myself, I couldn't possibly overtake the folks who are going to be speaking to you. And what I'd like to do instead is take a step up and really frame this in the broader conversation about what it means to put a progressive imprint on our democracy. Because we're all in the same orchestra, and we got to grow that orchestra. We may play different instruments, but that orchestra of our democracy, the orchestra of building an America in which everybody has access to opportunity, that's what we're doing here. And when you don't have access to courts, we have a challenge. But in the broader context, we have to understand that when we don't win elections, this becomes irrelevant. People ask me, Tom, you were a litigator. You did a lot of work at DOJ. This seems like a different job. And it is. But folks, the connective tissue here, people ask, what do you miss most about your old jobs in the Obama years? That's a simple question to answer. I miss helping people at scale. It's a definition of a good week when you can tell your kids, I just helped 2 million home health workers, mostly women of color on food stamps, get access to minimum wage and overtime protections. I just sued Joe Arpaio. Just helped put him out of office. That's the definition of a good week. Just settled the largest residential fair housing cases on behalf of victims of predatory lending. The corrosive power of fine print transformed the American dream into the American nightmare for millions of Americans. And when you lose elections, you lose control of the ability to help people. We have won the popular vote in 6 out of the last 7 elections, and we have been awarded the White House in 4 out of the last 7 elections. 4 out of the 9 justices on the Supreme Court now were appointed by presidents who didn't win the popular vote. Or at least in the case of Bush, he won it the second time around, but he didn't win it the first time around. And so as we have this conversation, we need to make sure we're also talking to our colleagues and friends in the progressive movement who are talking about things like the national popular vote. I'm proud of the fact that Maryland was the first state to enter the compact. 172 electoral votes are in place for the national popular vote compact. I wish I could say that we're not going to have another election where a person loses the popular vote but wins the White House. I'm not sure I can say that. And so again, connecting the dots of a broader movement, understanding, and this is where we need to do more, understanding the need to think long-term and build long-term infrastructure. You look at the Republican infrastructure, and you see ALEC that celebrated its 40th anniversary a couple years ago. And you see the Secretary of Education, one of the founders of ALEC. You look at every piece of anti-union legislation, anti-abortion legislation, voter ID laws, the brainchilds of ALEC. You just fill in the blanks, insert your state, and you move forward. You look at other infrastructure that's been built. You know, the Heritage Foundation, the Federalist Society. Now, we have CAP, and I was proud to be one of the early board members at CAP, and we punch above our weight, and we're a lot better than them. I have no doubt about that. Same thing with ACS. Been kicking the butt of the Federalist Society, but they've been around for a long time, and we can't deny that. And we can't deny the impact of things like Fox News and Sinclair, because this is more than just having the right policies. This is persuading people. You look at the number of Republicans who understand when they go to the polls. I may think that this guy I'm voting for is a pig. But you know what? I care about the courts. And I know what I want. I want to overturn Roe v. Wade. I'm going to ignore that. And they know that because they've been hearing it relentlessly. I've learned a few things in my current job. Not the least of which is the other side has had a 50-state strategy for a long time. And we had it from time to time. Ron Brown brought it in. Howard Dean took it to an even higher level. But then we kind of got away from it. And you know what, folks? If we want to have this conversation in the federal level, we've got to understand something. It's called arithmetic. If we can't win the United States Senate consistently, we can't be in this position. And if we don't compete in every state, we put ourselves at a competitive disadvantage. I was going through the list of opportunity that we have in the coming cycle. We had the most challenging cycle that we've had in perhaps forever in this cycle. We started out with 52 seats. We only lost one in a milieu in which we were playing defense far more than we were playing offense. And you look at the upcoming cycle. And as I look at it, you might be tempted to say there's a number of states where we can't compete. But if there's one thing that this cycle taught us is that we can compete everywhere, we can win everywhere when we organize everywhere, folks. And that is the lesson of this cycle. We have members of Congress from Oklahoma, Kansas, Utah, South Carolina. We have Doug Jones in the United States Senate from Alabama. We have the governor-elect of Kansas. We have a member of Congress, one of the first two Native American women from Kansas. Folks, what's the matter with Kansas? Not a damn thing. They're electing Democrats. And I bring this up simply because the connective tissue for me between this job and the work we did, Sue in Texas on voter ID, and working with that lady right there who's a serial activist, who's been one her entire life, to make sure that we protect access to reproductive health clinics, that we make sure that when you're pregnant, you don't get fired. The connective tissue here, folks, is very real. We've got to organize everywhere, and we've got to make sure we're electing Democrats up and down the ticket, because that's how we win. Alaska, it's in cycle in 2020. Mark Begich won before. He didn't quite make it to the mountaintop this time, but he or someone like him could do it again. Arizona, we now have Senator-elect Sinema. And I know a little bit about Arizona. 62% of people who vote in Arizona vote in Maricopa County. Joe Arpaio had 62% of the vote like 12 years ago, and then he lost by 12% of the vote in 2016 because people saw who he was. He was a Donald Trump clone. Not a coincidence that Donald Trump didn't travel to Arizona on behalf of the Senate candidate, because he did more harm than good if he had gone there. And even not going there, he still did harm. So we can win there. Colorado, Cory Gardner, we can win there. Georgia, we saw what we can do. If they hadn't cheated, we would have Governor-elect Abrams. There's no doubt about it. Iowa, we now have 3 out of 4 congressional seats, and we almost took out Steve King. We can win there. Joni Ernst, we can take her out with the right candidate. Kentucky, We have a governor's race this year. There's a guy named Mitch McConnell on the ballot in 2020. We can do this, folks, if we organize. I'm going to keep going down the list just to frame this. Louisiana, we have a Democratic governor, John Bel Edwards. We can do this. Maine, Susan Collins. Montana, we have a Democratic governor. We have a Democratic senator. We saw the president go in there multiple times, and it was to no avail. North Carolina. And let me tell you something about North Carolina, folks. You're going to talk a lot about how we make sure that we have a progressive movement talking about the importance of the courts. And you will be tempted to focus almost exclusively on the federal courts. I urge us to expand the aperture of this conversation. One of the people I had the privilege of working with in the Civil Rights Division under Bill Lee in the Clinton administration, we had two deputy AAGs. One was Tom Perez. The other was a woman named Anita Earls. Spectacular lawyer, now a member of the state Supreme Court. You should see what they tried to do to her because they were so scared of her. They passed a law changing the ballot order so she would be at the bottom, so people would get ballot fatigue. I'm not making this up. They did that. Remarkable. Wisconsin. One of my favorite things the DNC did, our mission is to elect Democrats up and down the ticket from the school board to the Oval Office. The day I realized that we could beat Scott Walker was the day after a remarkable election in April of 2018 for state Supreme Court. A woman named Rebecca Dallett. We can have a separate conversation about whether you elect Supreme Court justices. That could be a conference in itself. But let's put that aside for the moment. That's what they do in Wisconsin. And here's what her campaign platform was. Not a penny from the NRA. And as a person who got married 30 years ago in Wisconsin, I had two reactions when I saw that. Number one, courageous. And number two, possibly suicidal. Wasn't sure. But you know what we did, folks? We worked with others in the ecosystem to organize. And one of the things we did is we bought up a number of cell phone numbers. And we ran a very targeted texting program to African American and Latino voters in the Milwaukee area, reminding them of Rebecca Dallett's commitment to not a penny from the NRA. Again, this was in the aftermath of Parkland. And we thought best case scenario, we could win by 2% in Wisconsin. We won by 11%. We won in Milwaukee County, Dane County, Brown County, that's Green Bay. Secretary Clinton lost double digits in Brown County. We held our own everywhere. You talk about, and Brian correctly framed this, we've got to make sure that we make the judiciary relevant to people's lives. And people saw in Rebecca Dallett a woman who would fight for them, fight to uphold basic rights. We were able to help with a broader ecosystem to tell a story. And that's the story you told. And by the way, when people say there was a backlash, I don't buy that. I look at the federal data in the aftermath of 2018. Don't let people tell you that if you stand up for what's right, it's going to hurt you. I don't believe that for a heartbeat. I didn't see that here. Talk to John Tester. Didn't happen there. Talk to others. I don't believe it. And I don't think the data supports it. Was there a little bit of a ripple in the immediate aftermath? Yes, there was. But that was long before, seemingly an eternity before. And so what I'm trying to say here, folks, is one of the things I've learned in this job, and I didn't even get through the whole list of where we're playing offense in 2020 in the Senate. South Carolina. That'd be interesting. Texas, we almost won a Senate seat. We almost won a Senate seat, and we got John Cornyn in cycle. Tennessee, we have another opportunity there. Folks, we need all of us to be part of that broader ecosystem. That ecosystem that understands that we have to place the issues you're discussing at a much higher level so that when people go to the polls, they understand whether it's a federal race or a state race, that next governor is going to appoint Supreme Court judges, and that next president is going to appoint potentially Supreme Court justices, and that next senator is going to enable us to appoint district judges and others who are going to help us win. I used to teach at Maryland Law School after I left the Clinton administration. I taught a course on public interest advocacy. Rule number 1 at the time: never file lawsuits in federal court, because we were in the Fourth Circuit. And it was absolute malpractice at that point to file a lawsuit in the Fourth Circuit. Guess what? If I were teaching that course today, I'd go to the Fourth Circuit. And we saw that voter ID case out of North Carolina. Surgical precision, they correctly pointed out, is what they were doing in North Carolina to make it harder for African Americans to vote. And I can't help but digress to say, that party that talks about voter fraud, can we just have a conversation tonight about North Carolina congressional race? I mean, my God. And then that was like the Keystone Cops voter fraud. So please stop telling me about these issues when you have a problem in your own house. So I am excited to be here, and I'm excited for what you're doing. But I hope moving forward, and I hope moving forward as you discuss what we need to do to elevate these issues in the discourse for president, in the discourse for governors, in the discourse up and down the ballot. I hope we can recognize that we all have to help each other. We all have to make sure, I have to make sure as your DNC chair, that this is part of what we talk about. Making sure the judges, appointment of judges and justices, federal and state level, are part of our discourse. This stuff matters. Look at Pennsylvania, a spectacular example of what happens when you have a fair and level playing field. Barack Obama won 2012 in Pennsylvania by 5.5 points. The 18 Democrats who ran for Congress in Pennsylvania in 2012 won a little over 50% of the vote, and they won 5 out of the 18 seats in Congress. Why? Because we got our butts kicked in 2010, and they gerrymandered the bejesus out of it, and that was all we could win. You saw the same thing in Wisconsin this past November at a state level. Tony Evers won. We won every constitutional office, and yet you look at the state Senate and the state House, and that didn't happen. Why? Because we not only had to win those seats, we had to beat the spread in order to win. That's unfair. And that's part of the broader conversation that we have to have. And we all have to make sure that we're fluent in what's happening across our ecosystem so that we can come to each other's defense. Because we need to build a bigger orchestra. They've had a big orchestra for some time. And they've got the megaphones to amplify it, whether it's Sinclair at a local level, Fox at a national level. I've learned this from the outreach we've done at the DNC. Why aren't we penetrating, I ask? And I had someone in northwestern Wisconsin tell me, you know what? For most of the people I know, their principal sources of information are Fox News, their NRA newsletter, and the pulpit on Sunday. And it should come as a surprise to no one that our message doesn't penetrate. It should come as a surprise to no one that that person has elevated the issue of courts to the top because that person on the pulpit is saying, ignore everything else that this person has done and is doing. We have to focus on one issue of Roe versus Wade. And people buy it because that's their only source. So as we move forward here, we've got to talk about these substantive ideas, but we've got to talk about a broader communication strategy. We've got to talk about other reforms that are going to enable us to elect Democrats up and down the ticket so that we can actually have the capacity to implement what we're doing. That's why I chose to run for this job, because our democracy is on fire. It is a 5-alarm blaze. And what you all are first responders. And those first responders, we built beachheads this recent cycle. Getting the House of Representatives was absolutely indispensable. We flipped more Democratic governor seats from red to blue in one cycle than any year in something like 40 years for Democrats. We flipped 7 state legislative chambers from red to blue. If we flip 41 state house seats in 10 chambers, in 2020, we flipped 10 more chambers. And then we get to redistricting. This stuff matters. And this stuff that we're doing, and we must continue to do together, is going to matter and impact the success of what you're doing. So let me get off the stage so you can continue your work. But I wanted to frame it in a more broad sense. Folks, this is a meeting of first responders. Our democracy continues to be on fire. But I'll tell you the silver lining, and the reason I leave you and I come to you with unrelenting optimism is that the silver lining of this president has been that it has awakened our democracy in ways that I've never seen in my lifetime. And you look at the turnout. I was talking to a member of Congress recently, a generation older than me, and I asked him, "You ever seen anything like this?" And he said, "Once." And that was in the civil rights movement. And not surprisingly, our turnout in this midterm cycle, the last time we had it this high, was in the civil rights movement. And now we've got to sustain it. But we have to sustain it in a way that has voters understanding the importance of the issues you're about to discuss. Because if you don't have access to courts, you don't have access to justice. I used to teach the Caroline Products footnote 4. And that footnote seems to be gathering a little dust about what the role of judicial review is. And that footnote can't afford to gather dust because we have too many people here in America that rely on our Constitution for protection. We have too many people who need the courts to make sure that they can get access to justice. That's why those Republicans in Michigan and Wisconsin, shame on them for what they're doing. They understand, though, that if they limit access to courts, they're limiting access to justice. Shame on them. So let's continue to work together. Let's continue to make sure we're all first responders in this, that we all know what everybody else is doing, that we're working to elect people everywhere, that we're working to develop a blueprint, that we understand, and this is one of the most important lessons I learned as your labor secretary. If I could do it all over again, the most important gift you have when you have the privilege of working in a state administration, a federal administration, or a local administration is the gift of time. And all too frequently in the laudable search for perfection, we took a lot of time. And that had some consequences. I know it had consequences for me when it took us till November to pass some of our rules, and then we lost the election and we didn't have the ability to defend them, and they had the ability to turn them around. The same thing happens with judges. One of the things we have to do is make sure that in the press of business, this always remains a priority. Because it's easy to have to focus on other things that understandably command attention. But we must do more to impart that sense of urgency. The other side gets this. You know that. The pace of appointments. It's easier to appoint people when there's no experience necessary. But, folks, the gift of time is a gift that is fleeting. And that is why I'm confident you're going to come out of here not only with a blueprint of what needs to be done to make sure we elevate this. But a blueprint of practical suggestions, because it is not too early to be developing the briefing books so that we can hit the ground running on day one, January 20th, 2021, so that governors can benefit from the wisdom that you are discussing and developing in this room. And we can make sure we build an America that truly does work for everyone. An America in which our court system is really about protecting the vulnerable, not simply protecting those who are already in power. So, Brian, thank you for the work you're doing. Thank you all for being serial activists. I've been in many foxholes with all of you, and I'll get in a foxhole with y'all any day of the week, any week of the month, any month of the year. Have a great conference.
All right, one more time as Tom Perez leaves, give him a round of applause. I think that it's no surprise that he always sounds like he's losing his voice, and I think that that's the kind of energy and excitement and advocacy we want to bring here to the point where we're talking about the courts so much that all of us start to lose our voices as well. I'm delighted to bring up the next panel here. It's called The Court in Crisis. We have three fantastic panelists. I am, I guess I should say, Chris Kang, Chief Counsel of Demand Justice. Even more exciting, if there could be anything more exciting than me, we have a fantastic panel. We'll invite them to come on up. First up, we have Eleanor Marie Lawrence Brown. She's a professor of law and international affairs and senior scientist at the Rock Ethics Institute at Penn State. She's actually coming back here. She originally or previously was a professor of law at GW, and she directed the Institute for Immigration Studies. She has actually, in looking at her bio, has had entire careers related to work in the Caribbean, from private equities to utilities that I couldn't even begin to explain to you. We're very delighted to have her here. She also wins the award for traveling the furthest today, having come from Jamaica to join us, literally. Where she's working on a book, and she's come to join us and talk about what to do next on the courts. We also have Lisa Graves. Lisa is co-director of Documented, which is an organization that investigates corporate influence on our democracy. She's a prolific writer and researcher. And when you think about the courts, Lisa is one of the few people that has had a senior role in every single branch of government. She was chief counsel for nominations for Senator Patrick Leahy on the Judiciary Committee, Deputy Assistant Attorney General at the Department of Justice, and Deputy Chief of Article III Judges Division for the U.S. Courts. And one of the many reasons why we're so excited to have her here is that she was one of the first people to start calling for impeaching Brett Kavanaugh. Even before Brett Kavanaugh's first hearing was over, she was out there in Slate writing a persuasive case while I was trying to just write tweets of 140 characters of why we should impeach Brett Kavanaugh. Lisa put together a broader case. Finally, we have Todd Tucker. He's a political scientist and fellow at the Roosevelt Institute. His work focuses on judicial politics and political economy. He has written this fantastic report where if you showed up on time, you may have had a chance to receive, called Off Balance, 5 Strategies for a Judiciary that Supports Democracy. If you didn't receive a copy of it, they're available online, rooseveltinstitute.org, really making the case for the panoply of ideas that we should be considering with respect to reforming the courts. And with that, I will take a seat here, and we'll dive right in.
Hello, hello.
All right, well, oh, there we go. It says Mike. It was very confusing. It's the one on the top. So I do want to dive right in and start with Todd and thinking about the report that you wrote. You know, the title of today's event, the first part and the title of this panel is Court in Crisis. And I think sometimes when you try to come up with names of events, you think of things that might be exciting or perhaps a little hyperbolic to try to get folks here, and we're delighted to see so many people here. But I actually think the Supreme Court is in crisis. It's a crisis of legitimacy. It's a crisis of confidence as people start looking at it as really a political institution as opposed to an independent branch. And you've written this report that really calls for, and it says that court reform is imperative. Can you talk about some of the, I think, really many reasons you go through about why reform is imperative and what the crisis is we're at right now?
Yeah, well, first of all, thanks for having me. This is a great event and very inspiring to be with so many great activists here. You know, I think the thing to remember is that the court's crisis is really, it predates Gorsuch, it predates Kavanaugh. If you look at the history of the Roberts Court, you know, going back to 2005, relative to all of the other courts in the post-war period, it is by far the most pro-business, anti-worker, anti-consumer court of any, since we've been sort of keeping, you know, statistics that the Washington University puts together. And really, for the kinds of issues that the Roosevelt Institute focuses on, economic justice issues, corporate regulation, the court is really one of the main actors, in some cases the main actor of a branch of government. If you're concerned about inequality, if you're concerned about corporate concentration, you know, a third of the court's docket, you know, we're looking at 9,000 cases in the post-war period. About a third of the court's docket, it relates to economic justice, taxation, corporate regulation questions. And that's more than civil rights, that's more than criminal issues. It's really, it is the key economic policymaker, one of the key economic policymakers for the government. But what we've seen is that from campaign finance to corporate regulation, across all of these issues, the Roberts Court is far out of step with public opinion. In 2016, before Kavanaugh, before Gorsuch, a majority of Americans said for the first time that they disapproved of the job that the Supreme Court was doing. And if you look at the gaps between the way the Citizens United case went and the way that sort of where public opinion is, you can see it's a huge gap. There's been some interesting research looking at sort of public opinion of the court among sort of specific groups, you know, African Americans, people of color, women, and you know, for proposals as radical as abolishing the court altogether, you see sort of a strong sort of minority of people in those different demographic groups that are taking that point of view. So I think that's kind of, you know, part of the crisis that we see in the court is about that sort of longer term trajectory of the Roberts Court and how far to the right it is of even previous Republican courts.
And I really appreciate you sort of laying that out in the time frame, because I think that we're at this moment of progressive activism where it's becoming more apparent to us that the court is in crisis, that it's out of step, but it has been for quite some time. And I think one of the remarkable things, you know, Tom Perez talked about one of the lines that Chief Justice Roberts has tried to sell us, that judges are like umpires. To me, I thought one of the striking lines that he tried to sell us was just before Thanksgiving, where he went and he supposedly rebuked President Trump, and he said, there are no Obama judges or Trump judges. You know, we should all be thankful for an independent judiciary. And so I actually think the reaction to that was very interesting, and I'm sort of curious here, how many people here think that we have an independent judiciary and there's no differences between Trump judges and Obama judges? So for those of you watching at home, no hands went up. But I think one of the fascinating things was watching right after Chief Justice Roberts said that, the reaction among both conservatives and really a lot of progressives was to praise Chief Justice Roberts as if this were true, as if because we want an independent judiciary, if Chief Justice Roberts says it, then we can make it true. And to me, that line and that idea really sort of echoed back to the progressive support for Brett Kavanaugh from the outset. Even though they disagreed with him fundamentally on these core values and principles, they came up and supported him. And I think that one of the reasons why we asked Professor Brown to speak here and to come all the way from Jamaica to join us is that she wrote this very persuasive piece in Vox talking about the way that elites support elites and sort of the problems with that, and from, in particular, her perspective growing up in Jamaica. And so, Professor Brown, I was wondering if you could tell us a little bit about what drove you to write that piece and sort of what your views and analysis are of where we are and how we got here.
Firstly, is the mic on? Are you So firstly, thank you for having me. This is a wonderful event. I wanted to say the following. In reflecting on how the U.S. got to this point, and I say this as someone who became an American late in life, I think Americans took their country and their institutions for granted. And I think you see this best in the behavior of elites and in the behavior of elites around Kavanaugh. And what led me to write the article, a law professor at Yale, my former law school, Akila Mar wrote a piece in the New York Times indicating that despite being a liberal, he was going to support Kavanaugh. And I felt the article had a lot of what I call elite signifiers, things that elites do, which said that, you know, Kavanaugh is part of a club that I belong to. What did this remind me of? There was a very interesting article written by Simon Johnson with a colleague called James Park after the Wall Street crash, the financial crisis. Oh, are you hearing me better now? Okay, great. Do I need to repeat or did the video pick up what I said? Okay. So there was a very interesting article written after the Wall Street crash in which the authors asked, how is it that under progressive Democrats, we have come to a place in which Wall Street elites can behave very irresponsibly and not be held accountable by Democrats? And the answer to that question was that they shared something called cultural capital. Their children go to the same schools, they go to the same museums, they play on the same baseball teams. And in so doing, there had come to be a consensus that what was good for Wall Street was good for the country. And that had become so much part of the consensus that people could do extraordinarily bad things, take risks knowing that the taxpayers would backstop them, and there would be very little consequence for their actions. Now, what I think has happened with respect to the judiciary and the elites is a similar process. We have all been sold this notion that there is an impartial, independent judiciary working for the common good. People on the left have disproportionately bought that fiction. People on the right never bought that fiction. And if people on the left buy the fiction and people on the right do not buy the fiction, it means that people on the right are organizing, they recognize the judiciary matters, they're preparing people to put on the judiciary, they're behaving in activist ways, they're always acutely aware of the stakes and the implications in a way that people on the left are not, okay? And so that is how you come up with an article in which somebody who is a liberal says, this is a nice guy, we're part of the same club, I urge you to support him. Followed by many other articles about what a wonderful baseball coach he was, okay? None of which strike me as being particularly relevant when we're talking about voting rights and basic democratic legitimacy and gerrymandering and a woman's right to choose and all of these very, very important things. Now, the other thing I want to say about complacency, and I think it is, we will come to this a little later, but I think it's important that I say it early. We are all great supporters and admirers of President Obama, none more so than me, an extraordinary human being who did extraordinary things for the country. Having said that, you cannot become so complacent such that there are if signs that a foreign power is interfering in your election. And that has implications for things like your judges, which we will talk about later, because if the president is elected and the president appoints judges and there are questions as to the president's legitimacy, you then have questions as to what happens to the legitimacy of people who are appointed by a president when there are questions as to whether he was legitimately elected. Now, the reason that I'm saying all of that is if you are not complacent, if you realize what is at stake, if you're not going to be a nice guy because you all belong to the same club, when there are signs of, for example, interference, you talk and you talk early. The fire alarm needs to go off early. So that is the broader theme that I want to bring, not being complacent about institutions that have been taken for granted, because that's how you end up in the situation you're in right now.
Absolutely. Thank you. And I do think that that is what we're trying to fight, is the complacency. It is this sort of idea of the cultural capital that already now, just a couple months later, Brett Kavanaugh's back to coaching women as girls basketball team when Christine Blasey Ford still can't return home and can't return to work. It's that kind of cultural elitism that we're trying to break down. And what I think that is great about Professor Brown's writing, not only in this Vox piece, but also I came across this piece that you wrote in The Guardian afterwards. And when I think about the responsibility we have to fight complacency and to really be engaged, I thought it was interesting. During the closing days of the Kavanaugh confirmation fight, there was this very high-profile letter from law professors that was published, I think, in the New York Times, that hundreds of law professors joined, talking about how they opposed Brett Kavanaugh because he didn't have the impartiality or appropriate temperament to become a judge. And you wrote in Guardian that you didn't sign that letter. You didn't sign that letter because you thought that that was the least problematic aspect of his candidacy. And I think that that is exactly right. And I think that sort of as you try to figure out where progressives need to be and where elites need to be, that sort of, it was great that these people showed up at the end to do the bare minimum, but really, like, you talked about the responsibility that law professors should have. And I was wondering if you could talk a little bit more about sort of where it is that both law professors, but those of us who are engaged around the courts and progressives in general, really should be doing to shake that complacency.
Well, let me begin by saying that I took a lot of heat from my fellow law professors for that. And I recognize the good intentions in the writing and the signing of that letter, and I really grappled with it. When I said that, I felt that was the least of the problems about Kavanaugh. Kavanaugh clearly had a temperament that was very ill-suited for the job that he's taking. But long before we realized that Kavanaugh had a temperament problem, we realized that Kavanaugh had an honesty problem. And, and the honesty problem was that he went before the Senate and he said things that were untrue and that were demonstrably untrue. And my point is, long before you reach the issue of temperament, which is a stylistic problem, you have a substantive problem of dishonesty. And the substantive problem of dishonesty matters when you are standing in judgment of other people's honesty, right? Which is what a judge does on a daily basis. So I also believe, and I believe this very strongly, and I think we have to be, what I sense is happening now that Judge Kavanaugh has gotten onto the court. And, you know, there's a Federalist Society event, and he comes into a standing ovation, and he's speaking at his old prep school to a standing ovation. There is a normalization of behavior that should never be normalized. And we need to speak very, very clearly about this. We need to say and continue to say and tell our children and write in the history books that someone was credibly accused of sexual misconduct, and that person, despite the credible accusations of sexual misconduct, ends up on a Supreme Court. Now, if this happened in a developing country like my own, there would be an article in the international section of the New York Times saying, can you believe a man who was credibly accused of rape is on the highest court of this backward developing country? Am I not correct? That is what would have happened, right? So what I'm saying is, I am encouraging Americans to think of their country as if they were a developing country, and think of the stakes in the same way, and speak with the same clarity, and resist normalization of behavior that should never be normal. That's my point.
Thank you. And I wish I could say I planned that transition, but talking about Brett Kavanaugh's dishonesty was the point of Lisa's piece. Again, even before anybody knew that there was that Christine Blasey Ford had raised the complaint and had this experience in high school, you were there saying, like,
he should be impeached because he's lied. And can you sort of talk about, I know you wrote extensively about one of his lies, there were literally dozens, but really what led you to be the first to come out so quickly and so powerfully?
Well, I think, oh, am I on? I thank you so much, Chris, and it's an honor to be here. I, like many of you, was watching those hearings, and I just literally could not believe my eyes at the lies coming out of his mouth after he had taken the oath to testify truthfully. And those lies included lies about materials that were stolen from the United States Senate, from my own computer, and that were provided to him. And at first I was in a bit of shock about it, like just watching the whole thing unfold, and obviously seeing Professor Amar's endorsement and these other endorsements. It was really stunning to me. But when I saw his testimony, it was clear to me that he had not just lied just then, but that he had lied in 2004 when I was the chief counsel for the Senate Judiciary Committee, working on his nomination along with my colleagues, in 2006 when he came back up before he was confirmed, and he was lying again this year in 2018. And you know, not that long ago, a president was actually impeached for charges in the House that he had lied under oath. In a deposition, not even before the entire United States public in a hearing. And that's not why I responded. I responded because the fundamental character for a judge, as you point out, one of the fundamental traits is honesty. Judges administer oaths, they assess the credibility of other witnesses. Their job is bound up with having an appearance and reality of fairness, of honesty and integrity. And I believe then and I believe now, that Brett Kavanaugh does not have the integrity to sit on our highest court for the rest of his life or even for another day. Really, period. And our Constitution provides that judges can only serve while they exercise good behavior, and our Constitution provides for the impeachment of judges. And in fact, in the history of the United States, there have been at least 64 federal officials in which impeachment proceedings have been at least begun to be initiated. 19 times people have been impeached by the United States House. 15 of those times were for judges. Several of those times involved perjury. There's precedent for upholding this core issue of the rule of law. What does the rule of law mean in any setting if you have judges who are incapable and willfully do not adhere to the rule of law in their own testimony under oath for the most prestigious offices in our country, lifetime tenure? And so on September 7th, I wrote that piece saying he shouldn't be confirmed. The real question is that he should be impeached. And I think that needs to be part of the conversation. I understand the difficulties of the Senate in terms of an actual trial in the Senate, but just because you can't, at this point, prevail in the Senate doesn't mean that you should not be pursuing the enforcement of the rule of law in this country by beginning the conversation in the House about this man who plainly lied under oath to that body, to the United States Congress, and to the American people multiple times. But I want to step back a little bit beyond that just to say this question of our courts is one of the most vital questions we face in terms of the health of our democracy. There is no doubt that the United States Supreme Court under Roberts has begun an assault on our democracy. The most plain evidence of that, obviously, is the Citizens United decision, which is designed to allow some of the very forces that helped push and propel Roberts and Alito and others into that role on the court to help them hide their influence on our elections, on the appointment of judges, as well as on the makeup of Congress. And that dark money that the Citizens United decision unleashed has really adversely affected our democracy. It's undermined our democracy. And I think that's a fundamentally illegitimate decision. And it has spawned a whole series of illegitimacy. And I think we have to talk about the illegitimacy of our current Supreme Court, which is about to issue numerous, potentially 5-4 decisions, again adverse to our democracy, not addressing the manifest failures of that decision by the justice whom Kavanaugh replaces, by Justice Kennedy, that deeply flawed decision, which is going to continue to affect the integrity of our elections until it is fixed. But beyond that, this question of having fair judges it's not just having, quote, an independent judiciary, it's having judges who understand their role in our constitutional system. And I would say to you, to conclude this part, from my perspective, the reason you want an independent judiciary, the reason you want a court system set up the way we have it, is because you want fair judges who have the integrity and the courage to be a check on the political branches when they exceed their power. You could have a debate about ways in which the political branches exceed their power on substantive law, but if the political branches are basically constructing systems at the federal and state level that ensure their election, notwithstanding the will of the people, in defiance of the popular will, through jerry-rigging our elections, through redistricting, through not intervening on the impact on that, through not fully enforcing the Voting Rights Act, you have a fundamental crisis in our democracy, and that Supreme Court right now is a co-conspirator in the destruction of our democracy and the integrity of our democracy, and it's fundamental that we have a conversation about that being a real thing and about having a real, fair, and excellent judiciary for the American people in our country in the 21st century. So I would say we need to have a conversation about what it means to have a 21st century judiciary that brings justice to people in America, that looks like America, and actually has the integrity to recognize, to adjudicate, and to issue decisions that fairly represent the power of the people in our country and not just the power of the elites who helped install these justices into power.
Thank you very much, and I do want to get back to this legitimacy because it's a very different aspect of what we've been talking about, of way they're sort of dismantling our democracy. But I want to stick with impeachment for a moment because when you wrote that piece, and when senators started retweeting your article and other articles sort of documenting the lies that Brett Kavanaugh told, I sort of thought, like, this is it. Like, this is going to be the spark that lights real conversation, real movement to talk about potentially investigating, impeaching Brett Kavanaugh. And then the credible sexual assault allegations came forward and said, definitely, we're going to get this guy off the court, even if he's confirmed. And yet, it sort of died down a little bit. And I wanted to ask you, Todd, you've written this report, you talk about 5 different potential reforms, and one of them is impeachment. Sort of, what do you think? Do you think that impeachment is or should be on the table really at this moment, that it is sort of the appropriate potential response here?
Absolutely. I mean, I think there's this idea that impeachment is somehow a radical notion. I mean, what's radical is that the U.S. system of appointing judges to lifetime tenure and then not having any check on them afterwards. None of our trading partners do that. They have mandatory retirement. They have fixed terms. So impeachment is a tool commensurate to the decisions we've made institutionally in this country to give lifetime tenure. So it's a completely appropriate a check and balance on the judiciary. It's something that the founding fathers anticipated would be used a lot more than it has been. And it's no coincidence that of the officials that have been impeached, that have gone through, where the Senate's actually issued a conviction, it's been all 8 of them were judges, right? And this wasn't sometime, long ago in the 1800s. The last time was in 2010. So half of the currently sitting senators voted on impeachment of Thomas Porteous, a district judge. And if you haven't read it, I'm assuming most people haven't, go read the articles of impeachment. Read the Senate conviction proceedings. It's a fascinating read. If you look at the kinds of things that people like Chuck Grassley, Jeff Sessions, and others were saying about this judge, it wasn't that he had, stolen a plane or hijacked someone's kids. It wasn't some sort of crazy criminal thing. It was a much lower standard. It was about, is your actions, are your words, is your testimony before the Senate, is it becoming of the kinds of values that we expect to see upholded in our judiciary? That's it. So it's about honesty, it's about integrity. And like I said, I mean, this is one of the fundamental checks that we have in our system, and it's one of the only checks we have on justices. So I think that, certainly in the case of Kavanaugh, there's any number of arguments that one could make about things that he has done to merit impeachment, and co-sign many of the ones you pointed out in your article.
And I think that that's interesting because I think a lot of us think that the evidence is clear, but clearly at least some members in Congress need to be convinced. And so I was wondering, Lisa, you worked on the Hill, albeit on the Senate side, but like if you were on the House Judiciary Committee staff now, like what do you think you would be advising Chairman Nadler in terms of like, should he take a step back now and sort of pursue other legislation, or is this a time to actually start laying the groundwork to get some of these documents and to really have a real investigation into these credible sexual assault allegations, and sort of what would you tell him about when or how to start moving this ball along?
Well, having seen Jerry Nadler in action over many years, I would hesitate to tell him what to do. But
politely suggest, perhaps.
But I do think that it's important for members to not take any tools or weapons off the table, to make sure that they don't unilaterally say we're not going to do this or we'll rule something out. In this case, you have a situation in which the administration basically worked extensively with Kavanaugh's former deputy to hide from the American people key documents that the public has a right to know, right to see. So we only had just the tip of the iceberg in terms of the number of documents that proved that Brett Kavanaugh had lied to the United States Senate. There are more documents that were never provided to the Senate, never provided to the American people, that were kept hidden and that should be made available. And only through congressional pressure will some of those documents see the light of day. Some of those documents perhaps may never see the light of day, but the slice that we saw was enough to basically begin that process of saying, wow, he really did lie about what he knew and when he knew it. And so I think that I would hope that the House would, among the many things it's doing, because it can do more than one thing at a time, and the House Judiciary Committee can do more than one thing at a time, they would begin the process of trying to secure those documents. In terms of Dr. Ford, I always feel like we should say, we had eyewitness testimony. I feel like it's more than just, quote, an allegation. It's not like it was, blog. We had eyewitness testimony from a person in the room saying, this is what happened to me. And that is powerful and real. And even if people like Donald Trump and Milo, whatever his name is, want to parody it and make fun of it, yeah, whatever his face is, that doesn't make it not real. And the fact that there were Republicans, including Susan Collins, who are willing to ignore the compelling testimony before them doesn't mean that the House has to ignore that testimony, and it certainly doesn't mean the American people have to ignore that testimony. And so I think that there are a lot of things for the House Judiciary Committee to begin examining, including the Kavanaugh nomination and the Kavanaugh judgeships, the Circuit Court as well as the Supreme Court in terms of his behavior. But I think that there are obviously other substantial things to be examining given what you pointed out and many people have pointed out in terms of the foreign interference in our elections and what that means as well for our democracy. So there's a lot on the plate, and I don't think it all has to be resolved before 2020, but I sure hope there are serious hearings that illuminate these issues for the American people so they understand fully what's at stake when they go to the polls in 2020.
And it strikes me that potentially one of the reasons why there aren't more people talking about impeachment or even saying that the Supreme Court, it seems like in rooms other than this one, that saying that the Supreme Court is illegitimate might be a bold statement. And it feels to me that part of this is, again, it comes back to what Professor Brown's been talking about elites and the legal elite culture. Do you think that's true, Professor Brown, or do you think that, do you think the Supreme Court is illegitimate or could reasonably be called illegitimate at this point?
Okay, I want to take a step back to say two things. The first thing I want to say is when legal elites and judges talk about what judges are doing, they talk about legal principles and constitutional principles that are being impartially applied. And with respect to conservatives and a particular brand of conservatives, originalist principles in particular. Now, the reason that it is important for me to emphasize that is that the language is extremely important in how they characterize what they are doing and how we characterize what they're doing. So their language is about the impartial application of principles that are in keeping with original understandings of the Constitution, which they portray themselves as having no option but to apply in the way that they apply it. Okay? Now, the reason that that is important, and it goes so well with what Secretary Perez said earlier, is that that language of an umpire, if that is a language in the collective consciousness, the language we are talking about, which is the language of political actors who are making political decisions in robes, is a very, very different language. So you first have to have a conversation with the public where they recognize that here are people making decisions that are fundamental to the way our democracy is being conducted. And while they might be doing it in robes, let us have no doubt about the stakes. You have to say that extremely clearly. Because if you don't say that very clearly, and they're talking about the impartial application of particular principles, and you're talking about political actors, you follow what I'm saying? You have to be extremely clear about what is happening. So that's the first thing I want to see. The second thing I want to see, and this is extremely important, is if you do not have a conversation before you reach the conversation about the legitimacy of the judiciary, about the legitimacy of the president who appointed the judiciary. That's principle one. That's the fundamental principle. Now, I know it's a difficult conversation to have because people they cannot see procedurally how you get from the legitimacy of the presidency to removing all of these people who have been appointed by somebody who is fundamentally illegitimate. Now, we're still awaiting what Mueller finally does, but I think there is enough out there that it's extremely clear what happened. But I think if you do not have the conversation that way, and it becomes a conversation about individual judges, although, of course, clearly I have major problems with Brett Kavanaugh. Our problem is much bigger than Brett Kavanaugh. That's the problem I'm saying. That's the point I'm making. I'm saying there are dozens of appointments that are currently being contemplated, all of which are highly problematic. Yep. So Kavanaugh is the tip of the iceberg. That's the point I'm making.
So I hate to make a U.S. congressman wait as we run over, but to the extent that I went to college with him, I'm going to take a moment to let Lisa and Todd have the last 30-second closing thoughts here before we turn it over to Congressman Kavanaugh.
I would just say it's clear that the right sees these judges as politicians. That's why they invest heavily in putting them on the bench and making sure they have a Senate to do it. And that's what the Koch brothers have been investing along with whoever is funding Judicial Crisis Network for real. That's why they've invested in it. On the progressive side of the equation, when we talk about having fair judges, people don't necessarily put in an investment in political capital into having fair judges. But if you're putting people on the bench like the right is to overturn Roe or to stop addressing climate change, they're investing in real time. I'm not suggesting that we have a program of putting people to counter that. I'm suggesting that the Constitution contemplates a judiciary that's independent so that it can defend the rights of individuals, including, as Tom said, discrete and insular minorities in the Caroline Products footnote, where we have to have a judiciary that's a check on the excesses of majority power, including a majority that would basically design its own future and never-ending majority through Citizens United and through redistricting. And I would just end by saying this Supreme Court has petitions for cert for nearly 9,000 cases a year, and it has almost complete discretion 4 to 5 of those members of that court to decide its entire jurisdiction. It has the votes to do that, and it chooses to decide only perhaps 90 cases a year. It is going to handpick the decisions that it wants to make to affect our rights. And we as a people have a right to demand that we have justices that fairly respect our rights and not have justices that are hostile to our rights and are so supine to corporate interests and right-wing interests. That's just the bottom line.
Okay, thanks. And so, Todd, do you want to top that and close us out?
I can't top it, but I will just say one thing. I mean, I think some of the things that we've been talking about are structural, long-lasting problems in U.S. government that we just have to be active about. It requires an active citizenry to check and balance the different branches of government. I think we're all in agreement on that. We also have a different set of problems that are cultural, that are about the culture of the legal profession in the neoliberal era. Okay, and if you look at the judges, the justices that appointed by Obama and Clinton, they are to the right of the justices appointed by the Eisenhower administration, okay? So, I mean, I know that's maybe an unpopular thing to say, but I mean, it's important to point out that, while the center of gravity has just shifted so far to the right, where, the Trump appointees are voting twice as conservative as the Eisenhower's nominees did, and our current Democrats are voting to the right of the Eisenhower. So it's important to sort of address that issue head on. It's going to require long work of getting a different set of values in the legal academy and the legal profession. But I think that the work that we're doing now over the immediate term can be the beginning of that work over the longer haul.
Great. Well, thank you very much. Join me in giving a round of applause. All right, well, we're going to move right along. Up next is our next featured speaker, Congressman Ro Khanna, who I really did go to college with, and I'm excited to see him now in Congress. Congressman Khanna represents California's 17th Congressional District. He's vice chair of the Congressional Progressive Caucus, and the reason why we invited him to speak here today and to join us is because he's one of the few, if not only, national elected officials who's come out in favor of fundamentally revamping the court. And this is the kind of leadership that we need. This is the kind of boldness we need to see more of. And this is not sort of being out here front and center and taking the lead is not something that is new for Representative Khanna. When he was elected to Congress, he was one of just 6 elected officials to refuse campaign contributions from PACs and lobbyists. So he is clearly somebody who has seen the corrosive effects of money in politics. He's seen our democracy under threat and on the brink. He's been out there taking the lead to restore our democracy in so many different ways. And so it's no surprise to see him here today to talk about his views on the courts and how we as progressives must take another bold step if we really want to preserve our democracy and restore some semblance of independence and fairness in your judiciary. And so with that, my friend, Congressman Ro Khanna. Thank you.
Thank you, Chris. Thank you to Brian Fallon for helping put this together and inviting me on Twitter. He reached out and said, we're doing this. Would you like to come? And I'm flattered to be asked. I love the energy and so many of you thinking ahead about our court and what needs to be done. My thoughts are, let me put it right in the beginning, are very derivative. All of the ideas I had came from a conversation with Bruce Ackerman, who's a famous law professor at Yale in constitutional law. And Bruce has been talking about this with Steve Calabresi, who's actually a more conservative law professor, to think about what we need to do with the court and how do we avoid a constitutional crisis. One could think of a constitutional crisis 5 to 10 years from now or even sooner if we had, for example, policies that have 70 to 80% approval of the American public, Medicare for all or net neutrality or an aggressive climate change policy, passing the House and passing the Senate, being signed by the President, and being struck down by the Supreme Court. And it would create a constitutional crisis in this country, similar to the type of constitutional crisis we had back in 1937 when Roosevelt threatened infamously to pack the courts. And Ackerman and others who have been thinking about this say, we don't want to get our country to that point. That the tactics that Roosevelt had to use to pressure the court to not just adopt Lochner-era jurisprudence was not a crisis that we want to see happen again in our nation. There are several things I think as progressives, that we need to do about this debate, which is first to get the facts out there. Most Americans don't know that the Supreme Court wasn't created by our founders to have 9 people. The original Supreme Court had 6 to 7, I think it was 6 people in the initial Judicial Act. And Congress, time and time again, has revised the amount of people who are on the Supreme Court. That is a prerogative of the Congress. In fact, how many folks here are familiar with the memo that John Roberts wrote when he was in the Reagan administration about the jurisdiction of the court? Does anyone remember or seen John Roberts' memo? Where Roberts argues in that memo that Congress has the right to strip the Supreme Court of jurisdiction over issues of abortion and school prayer, because Roberts was concerned back then about a liberal court. We ought to be talking about John Roberts' own views about Congress's role in defining not just the size of the court, but the scope of the court. And that's point one. Point two, our founders never envisioned counter-majoritarian institutions of the court to be binding people 30, 40, 50 years after the original appointment. I mean, think about that. People today, I have young kids who are appointed to the Supreme Court today, could be making decisions 40 to 50 years from now affecting my kids when they are middle-aged. That was never the intention of our founders, partly because life expectancy wasn't that long, partly because they never envisioned that presidents would game the system by appointing people so young just to maintain partisan advantage. So one easy proposal that would clearly be constitutional is to limit the term of the court. Here's what I don't understand. The Republicans are for term limits for everything else except the Supreme Court. And I'm one of the few Democrats, I actually support term limits, even for members of Congress and for the president and for the Senate. But why can't we have term limits on the court? Then people come back and they say, well, if you have term limits on the court, that defies the Constitution, because the Constitution says a judge should be there for as long as there's good behavior, if you read the constitutional section. But the Constitution never says that a judicial appointment has to be to the Supreme Court. You could have judges appointed for life, but that doesn't mean the judge has to be a justice. So one idea is to have justices there for 18 years, and after they're done their time on the Supreme Court, have them go on a circuit court and live under the laws and precedents that they're making on the Supreme Court. This would not violate the Constitution, because they are still judges for life, barring impeachment, but it would prevent the gaming of the system of having people appointed in their 30s or 40s. And it would also fulfill Jefferson's ideal that people ought to live under the laws they make. If we had that kind of term limit, I think there would be great reform of the independence of the court, and people would probably appoint folks more when they were in their late 50s or early 60s as sort of the capstone of their careers, rather than for partisan work like Kavanaugh did, putting aside the whole incident of sexual harassment and sexual assault. If you look at Kavanaugh's route to the court of being a partisan hack, I mean, really running campaigns, that wasn't the intent of the type of person that the founders intended on the court. So Ackerman talks about, first, these judicial term limits. Second, Ackerman's view is that we ought to expand the court excuse me, in a way that actually would get consensus on the court's independence. So he talks about it in the view of court reform and not court packing. What does he mean by that? He says, how many folks here are familiar with the German system? In Germany, the court actually has two different branches, one that does statutory interpretation and one constitutional interpretation. And the court is large. In the United States, one of our problems is that far fewer cases are going up to the Supreme Court. It used to be during the 1980s that most cases actually made it, more cases made it to the Supreme Court. It was almost twice the number of cases were going to the Supreme Court. I think about 180 or so a year. Now you have about 90 cases going to the Supreme Court, partly because you have many more certiorari petitions that the court has to deal with. So the modern court needs to have greater resources, just from a functional perspective. And when you don't have a court able to solve circuit splits, you actually have greater unpredictability in the law that hurts not just causes that we may care about, but it hurts the predictability of our legal system, which is one of our comparative advantages in the world. So Ackerman says for basic reasons we need to be expanding the court like we have in many parts of our history. And his proposal to try to depoliticize it is to say, if we expand the court and at the same time require a supermajority of confirmation, 60 senators or 67 senators, then you will be depoliticizing who is on the court. So you could imagine President Sanders appointing something that requires Senator Romney's confirmation. And that is not saying that, he's going to put, Ayanna Pressley, Alexandria Ocasio-Cortez, and Rashida Tlaib on the court. It's saying that he's going to put people on the court who can get 67 votes to make the court more institutionally independent. And it's a way of talking about the expansion of the court that is still consistent with institutional independence. I'm not saying that the Ackerman proposal of 18-year term limits and expansion with supermajority is the only way that we can reform the court. But I offer that idea as one possibility for entering a conversation to make sure that the court is seen as consistent with democratic principles. We have to re-examine the fundamental premise that the court is somehow locked in to 9 people and that we have to have these high-stakes debates where the whole country is concerned about a single appointment. When Nixon appointed Rehnquist to the court, Nixon basically, if you read the history, thought very little of William Rehnquist. And they were trying to recommend him for more consequential jobs. And Nixon says, just put him on the court. Let's get, it's not a big deal. We'll just have him on the court. Who really cares? That used to be the view of the court, that yes, it was important, but no one thought that the Supreme Court justices, a single justice, should have so much power in our country. They weren't elected by people. They weren't elected by 700,000 people, let alone elected by 50 million or 100 million people. They were supposed to be people who would do their job. They were, you would know your Supreme Court justices like you would know your Fed Board of Governors. And yet we have this situation where these individuals have way too much power. Why should one person have this kind of sway over the nation? That's fundamentally anti-democratic, that they're staying there for these many years. And this is why our confirmation battles have become so heated. It's almost as the consequence at stake as the presidential elections. The first thing we ought to do is, as progressives talk about, taking power away from an elitist institution that is anti-democratic and restoring that power to the people and bringing independence to the court again instead of politicization. I'll end with this view. I believe very much that we need reform of our court, and we have to make sure that it does not become an institution that strikes down populist policies. But I think we ought to talk about it in a way that is consistent with our jurisprudence, in our history, in our Constitution. We shouldn't let the other side paint our proposals as simply trying to get partisan advantage or simply trying to advance our own goals. I believe we will lose that debate. But if we talk about our proposals of reforming the court to restore the constitutional purposes as more in line, actually, with our founding intent, and if we consult leading constitutional scholars, like people such as Bruce Ackerman, I think we can put together a proposal that will not only safeguard many of the progressive policies we care about, but also will be able to appeal to reasonable folks on both sides of the aisle who understand that reform is essential. So I appreciate very much the opportunity to come by to share some of my thoughts. And Brian, thank you. I don't know if we have time for questions or conversation, or do you, yeah, I saw a hand. Yes. I think that Jerry Nadler, who chairs the Judiciary Committee, has said that he wants to hold hearings on the nomination and what happened and what didn't happen, who was called and who wasn't called, whether the confirmation was thorough or not. I fully expect that he will be true to that and will have hearings in the Judiciary Committee. Yes, sir.
So, I think one of the reasons why liberals are so attached to the court is the heyday of the Brown versus Board education. And looking back and seeing that as a notable time, it was really making a lot of gains for progressives and liberals. Do you see in your reforms in that still being able to envision a court that would have that kind of courage? And would we be losing that in a sense?
Well, I definitely think the Brown versus Board of Education court was significant, but I think this court has, if you look at the history of the Supreme Court, I'm not sure that the court has done more good than harm. I mean, there was also the court that gave us Dred Scott and Plessy versus Ferguson and the Lochner era. You know, they had a moment of enlightenment, perhaps, with Brown versus Board of Education. But if you compare the horrible decisions of the court and the good decisions of the court, it probably cuts both ways. And I also believe that the Brown versus Board of Education came because of Thurgood Marshall and mobilization, and in response to political mobilization and changing of cultural norms, and at the incipience of a civil rights movement that pushed the court in that direction. So I think certainly if you had a more independent court, you would have the ability for people to try to interpret the Constitution in its most purest forms, and hopefully that would mean the safeguarding of rights and the safeguarding of minority rights against popular infringements on those rights. But I don't believe that we have to look to the Supreme Court as the safeguarding of democracy or our values. I believe people like Dr. King and Abraham Lincoln and Frederick Douglass and political leaders and mobilized communities and organizers have done far more to advance American justice than jurists on the Supreme Court.
Thank you.
Thank you very much to Congressman Kavanaugh for joining us. We're going to dive right back into the second half of the program. So we've talked about the crisis in the court. Next up is what's next for progressives. After Kavanaugh, we have our moderator, Jen Bendry, who I know you all read and follow religiously. I'm not just saying this because she's here. She is the best writer I've seen on the Hill when it comes to the courts and following the courts and keeping senators accountable. Her whole series of articles about senators like Susan Collins and Lisa Murkowski proclaiming to be pro-choice and pro-LGBT and not doing the right thing time and time again is a must-read series. So we're so delighted to have her moderate. We have Ellie Mistel from Above the Law, who you may know, also has been calling for expanding the court way back since April 2017. We have Sean McElwee, who wears a lot of hats. You may know him from Data for Progress. He also is a advisor to Project 12021, which mission is to expand the Supreme Court. And we have Professor Ganesh Sitaraman, I hope I did that right, who is here from Vanderbilt and has a lot of other different proposals to talk about what some of the options might be when it comes to court reform. And so with that 5-second introduction, I will turn it over to Jen. Thank you.
Hello. I'm Jen Bendry with HuffPost. I cover courts and judges a lot, so that's why I'm here. We're going to talk about court packing and how or if this is ever going to happen.
Court expansion is the preferred.
Court reform.
I am the moderator, and I'm calling it court packing, and if it can ever actually happen. So I can introduce everybody unless everyone's happy with the introductions, because I wrote it all down to be informed. Well, I'll just do it anyway. This is Elie Mystal. He's the executive editor of Above the Law, which provides news and insights on breaking legal developments. He is a supporter of court packing.
Yeah, so you want me to dive into...
Moving along. Sean McElwee is an advisor on the 12021 Project, a digital ad campaign focused on persuading Democrats to expand the size of the lower courts and add 4 seats to the Supreme Court once they regain control of the White House and Congress, ideally on January 20th, 2021. Sean is also the founder of Data for Progress, a progressive think tank. He also really wants to abolish ICE. He also supports court packing. And on the end is Ganesh Sitaraman. He's a professor at Vanderbilt Law School and a former advisor to Senator Elizabeth Warren. He's the author of The Crisis of the Middle Class Constitution. He is not an outright supporter of court packing per se, but he does support the idea of rotating a panel of judges onto the Supreme Court from circuit courts. And I'm Jen, and here we go. Can we get some wine up here, or no? It's like 8 o'clock, come on. Okay, so let's begin with a simple question, which is, why is it so bad having 9 justices? We've had 9 justices for a while, and the court has leaned left sometimes, it's leaned right sometimes. Why is it so important to change this? And any of you can jump in.
All right, can I jump in? All right, so I think it's super important to understand that the reason why we're fundamentally here is not, from my perspective, a purely partisan experience, okay? A lot of people on the right will say, like, oh, you only want to pack the court because you lost elections. No, we won elections. We keep winning elections, and somehow that doesn't matter, right? We live in a world where black people who win elections don't get to support Supreme Court justices, but white people who win elections do. So we have to start changing that. So number one, the reason why we need to think about having more than 9 justices is because we only have 7 legitimate justices on the Supreme Court as it stands. A. B, you can't look at the country that we're living in and come to the conclusion, any other conclusion, than our Senate confirmation process is broken. We can fight about who broke it. They'll say Bork, I'll say Garland. It's broken. It's obviously broken. Lindsey Graham is a sniveling hypocrite, and even he understands that it's broken, all right? Why is it broken? Well, because it's not just because the Supreme Court has too much power. I actually think the Supreme Court has exactly as much power as it's supposed to. Each individual justice has too much power, right? It would be political malpractice at this point to not oppose a justice who's going to vote against your political views for the next 30 or 40 years of his or her life, well, if it's Republican, his life. It would be political malpractice not to oppose that with everything you have. All Mitch McConnell did was take that to its logical conclusion, all right? So when you look at the brokenness of our confirmation process, I think one of the things you have to also look at is our district court confirmation process doesn't seem to be quite as broken. Part of that is because people are stupid and they don't understand that district courts are really important and like there's some dumbness that like helps. But part of it is that district courts have more justices. District courts work on the random wheel, right? So you have a Ninth Circuit with 21 or 19, whatever it is, 20 plus judges. But each case, for the most part, gets decided by the random wheel of 3 justices. They can hear more cases. It's more random. There's more appearance of fairness. And over the fullness of time, sure, a liberal or conservative can push the court one way or the other, but the random wheel of death doesn't lurch the court one way or the other. Right? We live in a world where, like, if Ruth Bader Ginsburg falls down the stairs, there goes abortion. That's insane. That's insane. And one way to fix it is by packing the court. So unlike some of the proposals, I'm not saying, oh, let's put 2 more, and then the Republicans will put 2 more, and then we'll put 3 more. No, screw it, 10. Go big or go home. 10 new justices. Now, my proposal is kind of more bipartisan. I'm willing to accept for the moment the current balance of power. I say 5 Republican justices and 5 Democratic justices. I think that's the only way you ever get Republican votes. 10 new justices, a 19-person Supreme Court, but most cases are decided by a random wheel of 3 justices. I think that puts us in a situation where the Senate can get back to confirming people based on their qualifications and not kind of simply based on their raw partisan politics.
So Ellie doesn't really have strong feelings on this. So do either of you want to weigh in? Give it a little fire?
I would also like some wine. I assume that was a request for the whole
It was
panel.
from myself.
Oh, okay. I want more justice on the court because I just love Supreme Court justices. I think there should be more. No, I think that we're in a situation in this country where the sort of inputs of democracy, the preferences of the general public are not being reflected in the outputs of democracy. We're not getting policies that actually align with the will of the American public. And one reason for that is because the Republican Party, which has a rather unpopular agenda, has continuously found ways to implement that agenda in a way that is out of the view of the American public. It's not something that we're talking about. So, for example, like the Affordable Care Act, right? Rather than try to make a case to the American public, the Affordable Care Act is bad policy, and you should, vote for us because we have this other vision of healthcare. The way that they tried to undermine the Affordable Care Act was they called up their friend, John Roberts, and they said, "Hey, man, can you do us a solid, quick?" There's a justice or a lower court justice right now who's willing to take literally any lawsuit that you could scramble together, no matter how absurd the merits, and he'll be like, "Yeah, that works for me. No more ACA." And that's a really dangerous place for us to be in as a country. And I think that the goal of the 1/2021 project is to begin getting rid of this mythology that has been perpetrated of the court as the umpire, and talk about the court as a fundamentally political institution that is enacting a political agenda, but one that is also subject to politics. We can do politics around the court, and we have chosen not to. Data for Progress did a study, which we put in the Nation, showing that Democratic politicians tend to talk about the court in more positive terms than Republicans. Democratic elites often talk about the court in very positive terms. The decisions that the court has made that we talk the most about are the decisions that tend to align with our values and not the decisions that choose not to align with our values. That is, we have chosen not to perform politics around the court. We have chosen not to engage with the court in a political way. And discussing court expansion and the other ideas are a first step towards really taking seriously the court as a political institution which must be moved in our direction and addressed in a political way.
So I want to step back for a second and say, what is the problem that we are trying to solve? Why are we here and having a conversation? And I don't think we would be having this conversation if Judge Garland was Justice Garland and there was a 5-4 Supreme Court that had him on it, and assume Donald Trump is elected and Justice Kennedy retires and Neil Gorsuch got the first slot that Trump had. It would still be a 5-4 court with Justice Garland on the court, and we probably would not be here right now. The thing that people are worried about, and the reason why we're here, is fundamentally the problem with the court is politicization. The court has gotten very political over time, and it's gotten more polarized over time. And the combination of politicization with the shenanigans recently that have delegitimized the court have put us in a place where it is very possible that we should expect, if there is another Democratic president, that president's agenda will be overturned on a 5-4 basis regularly, repeatedly, and along partisan lines based on the appointing president of the justices on the Supreme Court. This is a shocking and striking development. It is not something that is actually that common in our history. Even when Franklin Roosevelt was getting his New Deal proposals struck down by the Supreme Court, that was not along purely partisan lines. One of the four horsemen was, they're called the four horsemen of the apocalypse, of four of them who were very strongly opposed to it. But one of them was an appointment of Woodrow Wilson. He was a Democrat. This has not been the case that has been purely political in the modern history of the court since at least the New Deal. That would be a new thing. It is a striking thing, and it is a problem. So the question is, how do we solve that problem? And I think there are a number of proposals, and I just want to first disabuse you of the idea that the 18-year plan is a good plan. I think it's not a good plan. And the reason why is it doesn't solve the problem of politicization. It's designed to solve the problem of people being on the court for a very long period of time. So there's a generational problem. Maybe our oldest justices don't know much about technology and they're trying to deal with a lot of cases about technological privacy. I mean, if you think that's the problem, your 18-year plan might have something to do with that. But if you care about the politicization of the court, particularly the polarization of the court in this context, the 18-year plan might actually be worse. There's lots of different ways to design it, but one of the problems is after you spend your 18 years on the court, what do you do as a judge? Well, you might want to run for president. And as a result, you might spend your 18 years being very political in order to build up a base. You might decide you want to be a Fox News contributor. You might want to work on this street right here, K Street, as a lobbyist. Those are all things we could easily imagine justices doing afterwards. They might become more corrupt, more political, more transparently part of the problems that we see already in Washington. This is not to say nothing of the fact that the confirmation process for the 18-year terms will be just as bad as the toxic process we just went through. So I don't think it solves our political problems. Court packing might or might not solve the political problems. The challenge with court packing, I think, is that while it solves the problem of the next Democratic president having their entire agenda overturned on political lines, it may be that the next president after that, who's a Republican and has a Republican House and Senate, decides to change the scope and size of the court again. And then you just have this tit for tat back and forth. Now that might be the case. Another option is you have sort of what happened in Roosevelt's time. You pack the court, let's say, and then there's 5 Democratic presidential elections in which Democrats win in a row, 20 years of Democratic presidents, and by then just a new norm is set. There's a new equilibrium. We've got a bigger court. That's just where it's going to be. That might be possible also. But if you're worried about the tit for tat kind of world, court packing is a problem, potentially. It just makes things more political rather than less political. We still have this kind of feature where the Supreme Court is a function of every congressional election, every senatorial election, every presidential election, where lots of outside groups are spending money to try to convince people about the court, and where one side mobilizes a lot more than the other on constitutional issues as well. The third option, one that I've proposed, and I'll give you a couple versions of it, is that we have a different kind of court. One approach is that we appoint every federal court of appeals judge as an associate justice on the Supreme Court. So yes, packing the court, but packing it to 180. All the federal court of appeals judges would be appointed associate justices, and you would have a Supreme Court that would serve in panels of 9, and they would serve only for 2 weeks at a time. And the rest of the time they would be court of appeals judges. And so for 2 weeks, they would hear the cases that come up in those 2 weeks. They would address those, and that's it. And they would go back. And so their culture would be the culture of court of appeals judges. They would not believe themselves gods who are defining the Constitution. It would also be something where particular justices could not have an agenda over the course of multiple years to try to advance some sort of ideological goals that they have. And parties would not be allowed to bring cases knowing that they can target one swing justice. You would not know who the judges are going to be in a case in front of you. So that's one approach that I do think ratchets down the temperature of the politics of the court. I think it would also make the court a lot less important in our political lives, because we would not have the cult of personality around certain judges, and it would be just much harder for the court to to be involved in kind of the big cases. That would have to be coupled also with a supermajority requirement for overturning federal statutes. The other policy idea that we could do is we could expand the court to 15, have 5 Democratic judges, 5 Republican judges, a partisan balance requirement like we have on some multi-member commissions in certain agencies right now. And then you have 5 judges that are selected from the Federal Court of Appeals. But the way that's picked is the 10 justices have to agree to those 5. And if they don't agree unanimously, they have no quorum and can't hear any cases for the year. And so this would force the 10 to pick 5 judges who are somewhat palatable to serve and who are going to be moderate, and there might be some horse trading on some things, but they would have to agree on some set of things, and you'd have this kind of partisan balance. And that would be a way to also ratchet down the politicization, but through a different kind of mechanism. So those are some ideas. It's not to say that necessarily court packing may or may not be bad. I think under some conditions it could work, under some it might not. And so that's what, so those are some initial thoughts at least.
It feels very Roman and interesting, Roman Republic, and that's fine until like Cincinnatus declares himself Supreme Court Justice for life, and then we have issues. I want to disagree with the premise that the problem is that the courts have become politicized. I think the problem is that they've always been politicized, and our side won't get into the game. All right, like the Republicans have figured out that the courts were a political actor a lot longer than we did. And if you go back in our history, while I agree this is a rare situation where we have a very partisan split, but at any point in our history, the people who thought themselves conservatives have always understood that the courts are their best political way to retard the progress of the country. And if you don't believe me, you can go talk to my friend Dred Scott, who would tell you the same damn thing, right? The courts have conservatives, not always Republicans, but conservatives have always understood that the courts have a retarding power on our ability to progress, and our side rarely thinks of them that way. So I'm like, bring a fight, let's go.
So one thing to think about, though, is if that's the concern, right, that's a different kind of concern, it actually goes against something you said earlier, which is that you think the court has exactly the right amount of power. Now, throughout American history, there's only one period of time when the Supreme Court has been reasonably favorable to the kinds of preferences that liberals tend to have. That was in the mid-20th century. The rest of American history, the court has been hostile to progressive and liberal kind of goals. So another way you might think of the problem is that the problem is not the structure of the court, it's substantive. It's that the court has too much power to do too many things. There have been many people throughout our history, and there were times in the court's history when the court did a lot less activism. It struck down a lot fewer statutes. It was not as engaged in the general affairs of trying to govern the country. And it was decentered from the kind of heartland of political life, which was legislation and politics and democracy. So there are proposals there, too, which we could talk about if people are interested. Some people have proposed stripping the jurisdiction of the court, higher barriers. I mentioned it, 2/3 vote to strike down federal statutes is another kind of example of this type of thing. So one concern is maybe if we think that's the issue, that it's that the court has too much power. And in fact, maybe if you're a kind of through and through small d Democrat, what you want is for the court to have less power and for democratic institutions that are politically accountable to have more power. And I think that would be another way to get at some of these issues.
I mean, have you tried to get a congressman to understand strict scrutiny for equal protection? Because it doesn't go well.
So, legal scholars have been debating these ideas for years, all kinds of ways to remake the Supreme Court. One idea is 18-year term limits for justices, which would let each president appoint 2 new justices per 4-year term. Another idea is to strip the court of its jurisdiction over certain issues. And another idea, of course, is adding new justices to the court. But my question is, how feasible are any of these plans? As far as I know, Congressman Kavanaugh, who was just here, is the only person I know of in Congress who is openly supportive of the idea of adding more justices to the court. And Jerry Nadler, who chairs the House Judiciary Committee, has said he's not interested in talking about impeachment of Kavanaugh or anything like that. So how realistic are any of these creative ideas, and how do you get lawmakers to even pay attention to this and from there do something about it?
How realistic was it that you could hold open a Supreme Court seat for 18 months just because a black guy nominated it, right? Feasibility is something that you assess afterwards, right? If you have the plan and you have the motivation and you have the grassroots organization, all sorts of things become feasible that didn't seem feasible before. I just saw Republicans pass Obamacare repeal 11 billion times with absolutely no chance of having that pass, right? So don't talk to me about feasibility. I want Kavanaugh impeached on day 1, and then day 2, and then day 18, and then day 27 until we get it done, because that's what the Republicans would do if they were in the same situation.
But if that's your very flat, boring, uninspired argument, then you would be doing nothing different from the House Republicans voting over and over again on something that isn't going to happen.
Yes, but I'm right.
But you can go home and feel right, but nothing changed.
It doesn't change in the immediate term. Look, we've lost the last battle, right? We didn't answer the bell in 2010. We didn't answer the bell in 2014. That battle is lost. The court is lost for a time. We need to start fighting the next battle. And the next battle is going to be whenever the wheel comes back around, because the wheel will come back around, according to my Game of Thrones history. It will come back around, and when it does, the Democrats have to be ready with a plan. The Republicans didn't just like wake up in 2016 and be like, oh my God, we control the courts, we control the presidency, we control Congress, what are we gonna do? We should nominate some judges. No, the Republicans have been planning this for a generation. They came out of the gate. They knew exactly who they were going to nominate, not just at the Supreme Court level, but all the way down through. They've got a deep bench of guys on top of guys on top of guys. They know exactly what they want. The Democrats, if Hillary had won, we would have been like, so we're Garland. Is that still a go? Like, we would have had no idea of what to do with that power had Hillary had won. So part of what I'm advocating is, yeah, we're going to take some lumps in the short term, but we have to start building the bench and building the ideas and building the energy so that when the wheel comes back around, we know exactly how to capitalize on it.
I mean, there were 0 congressional Democrats who supported abolishing ICE on January 1st of 2018, and there are a dozen now. When you tell me that there's already 1 who supports expanding the court, I'm like, fuck, that's a popular idea. I'm psyched. I think that this is exactly, what Ellie said is exactly correct. We are really far behind on this. And they have been creating a machine to influence the courts for a very long time. There was actually a recent study that came out by an economist named Suresh Naidu, who showed that among judges who attended a libertarian conference, their judicial opinions moved to the right economically. They ended up sentencing defendants to longer terms, and it actually increased the racial disparity in the sentences that those judges meted out. So this is merely to say that there has been, on the right, a long, deep investment in the Supreme Court and in the courts more broadly. And what the sort of talking about this in a really serious way and talking about this and getting the Democratic base fired up, not just about Citizens United, but about the role that the court plays in their lives every day. And we don't talk about that. We don't talk about every time there's a school shooting that it is a Supreme Court decision, Heller, that has limited our ability to pass gun rights. We don't talk about the fact that John Roberts is the reason that many states no longer can have voluntary desegregation proposals. There were so many ways every day, pollution, every time, there's a kid with asthma. Like, why don't we talk about, hey, John Roberts gave you that asthma when he struck down, common sense regulations because the Republican Party was too terrified to strike down those regulations through Congress. And I think that if we start doing this and we start making this demand, Democratic politicians will have to begin responding to this. And Roe is obviously ahead of the curve, but our goal is to, take what we saw with the Kavanaugh hearings and light a fire, under the feet of congressional Democrats to get them to take very seriously the role that the court is playing in the lives of the base of the Democratic Party, and we need to actually do something to address it.
So I think we need to distinguish two kinds of feasibility. One is constitutional feasibility, which maybe we can talk about later if people are interested. But the second one is political feasibility, which is what we've been talking about. And on political feasibility, I think one of the challenges to start, the kind of baseline challenge, is there's a bunch of scholars who've done work to show that there's an asymmetry in polarization with respect to playing constitutional hardball. That people on the left don't do it, people on the right do it. And so one of the challenges is that if you are interested in constitutional hardball as somebody on the left, that your side does not do that. And that is a thing that's a problem. That makes it less feasible that these things are likely to happen. There's just many fewer Democrats who would be willing to do this kind of thing, at least historically, looking backwards. That's at least what the political scientists and legal scholars suggest. The second thing, though, is looking forward. It may be the case that the kind of thing that you would be able to pass, because you've got to think about this. This is a massive reform. Any kind of these reforms we've talked about would be a massive reform to one of these central governmental and constitutional entities in our society. I mean, the Supreme Court is a major part of our society. The likelihood that that is going to be pushed through by one party in a political way maybe is possible, but it would be very striking if that's the case. And so part of the reason why I and my co-author Dan Epps have proposed these other approaches, the lottery approach and the kind of balanced partisan balance requirements approach, is these are things that it's plausible that maybe they would have to get pushed through by one side. You could imagine some people on the other side supporting them, but after the fact, you could imagine people on the other side supporting it. So there's some stability that's possible there because people on the other side could live with that as a kind of stable solution, which I'm not sure is the case for court packing, for example. So there's a level of plausibility that depends a lot based on which of these reform packages you pick, both in who you can get on your own side, who might want them, who on the other side might want them, and after the fact, whether they have any political stability to them.
And I go back to one of my proposals, is that you have to get Republicans on board, again, if not in the initial question, then later, to have any kind of stability. That's why I say, when I'm talking about court packing, I'm thinking of preserving for them their illegitimately gained balance of power. When I say I want 10 more justices, I'm saying let's do it 5-5. Because I'm thinking long term, if we sell it as a court reform as opposed to a court pack, if we sell it as fixing our clearly broken judicial confirmation process, if we understand that over the course of history, if a justice is going to flip, they're going to flip left. Something about being educated, I think, pushes people to the left over time. I'd rather take my chance with 5 moderate Democrats, and look, if it was just me, I would just have, whatever. I would have the most liberal Democrats possible, right? I would rather take my chance with 5 moderate Democrats and 5 moderate Republicans and letting that play out for a while and getting, again, sniveling hypocrite Lindsey Graham to admit that this was a legitimate way to fix the courts. Certainly if you present it to the Republicans as, we got the votes to do this without you, so we could do 10 without you, or we can do 5 and 5 together. I think there are Republicans out there who understand that the confirmation process itself is broken.
So how do you guys see this happening, practically speaking? Are we talking about the Senate needing to find 60 votes to do something like this? Or are we talking about getting rid of the legislative filibuster? How do we get there?
Yeah.
So I think that the concern that I have and why it's important for us to be having these conversations is that it is highly plausible that going forward, half the country will think that the institution of the court, when it issues certain sets of decisions, is an illegitimate institution. And I think that's bad for the Supreme Court. I think that's bad for the Constitution. I think that's bad for the country. The way that I think change will happen is that there is a lot of pressure around the delegitimization of the court, particular justices, the cases that they're deciding, and most likely that would come at a time when the court strikes down a variety of signature proposals by a Democratic president, given that it is a conservative court at the moment. And in that context, what would be likely to happen is there would be a massive backlash to that, and then proposals would be on the table. And that would be a time when there would be some attention to it. Now, in that context, would there be 60 votes? Maybe, maybe not. Would there be 50 votes? Maybe, maybe not. That would constrain the context as well. So it's hard to know in any given moment. I think at a minimum, it would be hard to imagine in the scenario that I would envision as the most plausible, a Democratic president's signature achievement struck down. You would probably need a Democratic Senate. You would need a Democratic House. You would need at least 50 and the will to get rid of the legislative filibuster, or more than that. And even then, all of that would be a very, very radical thing to do. And that's why I think a radical reform that is one that is, tamping down the temperature of politics is probably a better idea.
And see, I think you got to ratchet it up, because what you need is to turn Democrats into single-issue voters on the courts. The Republicans are already there. You go into some of these homes. I'm from Long Island. I live in the suburbs. Like, I can go find Republicans even in New York State. And when you go, you'll see them, and they're all like, well, the Democrats win. They're going to have abortion, and they're going to have gays kissing on each other. Who wants that, right? And you ask the Democrats, well, what are you offering? And they're like, fairness, fundamental fairness. That's not a good argument, right? You gotta ratchet up the pressure, and you've got to turn Democratic voters who maybe sometimes come out in the midterms, kind of usually come out for presidential elections if they like the guy. Sometimes women, I don't know, she seems too powerful. You got to turn them into motivated single-issue voters. Here's the thing that I care about, and I'm going to go show up every election, every special election, every primary to vote on this issue. I think you only get there by raising the temperature, not like explaining to them how, if we do this, everybody will get along and it will be better.
I'm not used to being the squishy centrist in the room. So my perspective on this is like that the ideal situation is not to have the court strike down signature pieces of Democratic legislation if it can be avoided. And I think that the way that you do that is you get to a point in which the Democratic Party is going to be credibly ready to play constitutional hardball. And I think that one of the key steps in that is to move the way the Democratic voters, but also more importantly, the journalistic community, political elites talk about the court and the judges specifically. And the framework we always used to talk about them is very neutral. We don't talk about the fact that, look, John Roberts has made a lot of decisions that are in the material and electoral interests of the Democratic or Republican Party for him to make those decisions. And it's really hard for me to believe that if gerrymandering was as bad as it currently is, in a way that favored the Democratic Party, that John Roberts would be as hesitant to rule that gerrymandering is unconstitutional. And so, honestly, I think that journalists should, have a little R next to John Roberts' name whenever, we talk about him. And I think that, the decisions that John Roberts makes and the court makes should be polled. And I think that we should talk about their favorables. They are acting like politicians treat them like politicians, talk about them like politicians. And Democrats should not be afraid to talk about the very real political implications of these decisions, like Shelby County, and how those decisions have enabled widespread voter suppression across the country. And if we start, and I think that this is why it's important to ratchet up the pressure, is because right now John Roberts does not feel political pressure. He does not feel as though the legitimacy of the court is broadly in doubt. He does not feel constrained politically to make his decisions, and he should feel constrained politically because he is.
You can go into a Walgreens in this town, in this politically active town, and have John Roberts standing right in front of you, and most of the people in that Walgreens won't recognize who he is, right? That's a problem, because that means when John Roberts goes about his little life, nobody's talking to him. Nobody's saying like, yo, you screwed me. Yo, you took away my vote. Yo, you took away my voting rights, you jerk. Nobody tells him that. And that's, part of what you're talking about. This is why I'm also like a big fan of cameras in the courtroom. Like, we need to see yes, they have lifetime appointments. Yes, they are above political pressure. Let's play that out a little bit. Let's see how above political pressure you are when every time you go into a Publix, I got 8 black people being like, where's my vote, John? Yo, where's my vote? What happened? Like, these people need to understand that if they're going to be the minority body standing against the stride of history, that needs to sound different to them than it currently does.
And this shouldn't sound extreme. I mean, Judicial Crisis Network runs ads around, court appointments. They do this regularly. Give Brian Fallon your money, to start running ads. We should be bird dogging these Supreme Court justices. We should be, every time that they speak, even if it's a closed door event, like we should be recording that. They should be subject to direct action regularly. Clarence Thomas is constantly violating the standards of his office and should be recusing himself from far, far more decisions. But he does not do so because there is no political pressure that is being placed on him. And the right is far ahead of us on this, and we need to catch up.
Can I just piggyback on this, because this is a really important point, and I don't think a lot of people are clued into this who don't follow this every day. The Supreme Court is the only court in the land that has no recusal rules, right? Every other court, there's actually a rule you have to recuse yourself with this, right? Supreme Court, it's like up to them. I don't feel like recusing myself. I think I can be impartial. What the hell is that? Democrats took back the Congress. We should have recusal rules ready for the Supreme Court, by Martin Luther King Day. Give him a birthday present, right? And then let the Senate vote against that. Make really bipartisan, good government, anti-corruption recusal rules, and let the Senate vote that down. That's going to look bad for them if they have to vote that down. It's going to look bad for Trump if he can't sign that bill. Put rules in place that would prevent, when we're talking about Clarence Thomas is the most obvious one, because his wife is all out there having already established positions on every critical issue. Have recusal rules that prevent that from happening, and let the Republicans vote it down if they want to look that bad doing it. But that's something the Democratic House could do by Martin Luther King Day.
And I focused on the sort of, the negatives and making people understand the negatives of Alito. But at the same time, there are genuine progressive champions on the court. I mean, I think that in the same way that John Roberts should be a household name, Sonia Sotomayor should be a household name. Her writing on racial justice is incredibly powerful. Her writing on criminal justice reform is incredibly powerful. Her writing on reproductive justice is incredibly powerful. And she should be a progressive hero. She should be someone that progressives aspire to be. And we should have these avatars of hope because that is part of the political process.
So I want to sound a different note here than especially the last comment. I don't think that we should have a system in which the Supreme Court is so at the center of our political life, and in which there are progressive heroes or conservative heroes or any heroes, and it would be great if you didn't know the names of any of the justices. And the reason why is because the Supreme Court should not be, and we should not think of it, as the saviors of policy or a place to accomplish policy goals. If you want to accomplish policy goals, we have a democratic process for that, and that should be the center of where we focus our attention. We should build movements, we should pass policies. That counts if you're on the right, it counts if you're on the left. It should happen through a political process that is democratically accountable. That is what it means to be in a constitutional democracy. The idea that we instead want to focus on making the court the people who are going to save us from ourselves or save us from others is an excuse to not focus on democracy, which is what we should be doing as a primary focus of what we're up to. So to separate two things, I mean, there's one question that you guys have mostly been talking about, which is tactics about the short term and making change on the court at a structural level. But I think the aim that we should have, putting aside the tactical questions, I think the aim that we should have is for the court being less of a center of political life, less of a major part of policy making, and that it should not be this idea that either side or both sides are trying to use the court as activists to accomplish our goals. What it should be is that the court should not be activists. They should be very limited in what they're up to, and that policy should work through Congress, and that the courts should defer largely to the choices of the democratic public.
Yes, like the court should not be activist, and also Republicans shouldn't go around collecting black people's absentee ballots and then burn them. But that's what they do. And if we're not saying it and we're not yelling through the streets, this is what's happening, we're only further enabling them. I have no disagreement with you on the ideal from my perspective is for the court to be as weak as possible because it's made up of lawyers and I'm too dumb to be a lawyer. And I want it to be weak, but it is currently a very real locus and domain of politics. And the Republican Party and the Republican base understands that, but our base does not understand that.
So this is just why I'm separating the question of how you want to think about political tactics in the short term from what the end goal of a design would be. And I think the goal of a design should be to ratchet down the politics and reduce the power of the court in part within our political system so that we have a court that is less activist regardless of the composition of the court. I think that is a desirable aim.
But it's never been that way. And again, I go back to kind of the minority rights tradition. The point of a court, of courts, is to be kind of that last bastion of minority rights against a majoritarian culture. And consistently throughout our history, but for 20 good years with Warren, the courts have frustrated minority rights. And they get away with frustrating minority rights in part because they operate in secret, right? So if you tell me where I can go vote to stop the Muslim ban, I'll go vote. I'll vote against no Muslim ban, right? I'll vote for that. Most of the country will vote for that. That's an unpopular policy. It can only thrive and exist when we have courts like we have them now. And the courts can only get away with that when the vast majority of people don't understand what they're doing.
Obviously, Ellie needs to hang out at Walgreens and wait for Clarence Thomas.
He's right there. He's right there.
On Capitol Hill. So FDR tried court packing and failed. What do you have to say about that?
In a long, long time ago, in a galaxy far, far...
It wasn't that long ago.
I think that the failure of court packing under FDR has a lot to do with the fact that it was presented as a partisan solution. FDR did not like the decisions coming out of the court, and he said, here's how I changed that. And that's why I'm kind of saying we can't come at it from a partisan solution, we have to come at it from a reform solution, right? If we wait until they cancel abortion, or all but cancel abortion, and then say well, we need to court pack now, it's too late. We've lost the argument then, right? If you come at it from a reform tradition and say this is going to help all of us, A, you don't get to the point where they overturn Roe v. Wade, but B, you have a better chance of kind of learning the lessons of the FDR scheme.
I mean, my perspective on the sort of FDR thing is he did get much of the New Deal eventually passed, and I mean I think that escalating the politics of that and showing that a wildly popular president was actually ready to put his money where his mouth is, when actually ready to do politics in order to achieve his policy aim, was no small part in that. And I think that that's the vision that I have. That's the vision we have at the 2021 Project.
I would add just one thing. This is sort of cute, but in one way, FDR did pack the court. He did it by winning elections over and over and over and over again. And it turns out if you keep winning elections, you will eventually get to fill empty seats in the court, and FDR very much succeeded in that, to the point that by the end of his time, it was very much a Roosevelt court, not a court that he inherited. So it was a very different court by that time. So I just raised that there's an element of that being critical here too.
Okay, here's my last question. Why do you think Democrats have been so terrible about engaging? Haven't even asked the question yet. Why do you think Democrats have been so terrible about engaging the public in the courts in terms of fights on judicial nominees and the importance of federal courts? And what do you think the most important thing is that they should do right now in the Senate or in the House, primarily the Senate? What should they be doing that they have failed to do for so long?
Give Brian Fallon money, right?
That is so kiss-ass. Well, why have they been so? Why do you think they've been so? Why have they been so crappy for so long on this? Republicans have owned this.
I think Democrats have been crappy because Democrats have generally been led by white men, and white men are scared of the abortion issue, and they've been unwilling to take that head on. And so they're like, oh well, it's not just about abortion. It's about no, it's about freaking abortion. And the Republicans know that, and we know that. And if we were led by not white men, I think that we would have been much more stronger and better about defending that essential right. And again, joining the goddamn battle. A. B, I think Republicans do a much better job of developing their bench. And again, when you look at the Federalist Society, like I keep saying, this has been a generationally long project for them. They understand about grooming and developing not just the Gorsuches and the Kavanaughs. They're the tip of the spear. They're backed up by an entire undercurrent of legal philosophy, of law review articles, of professors, an entire, as much as compared to, law schools aren't for conservatives, that's BS. There's an entire cabal of this conservative groupthink running through our legal system, and the Democrats have not joined the game. I'll give a personal story. I went to good law school. I'm a loud black man who can write. If I was a conservative, they would have identified me in law school. The Federalist Society would have identified me in law school. They said, you're going to go here, you're going to work here, we're going to put you here, da-da-da. Maybe I didn't have the judicial temperament. They would have found, I'm intellectually consistent, they would have found something for me to do. They would have found some way to deploy, if I was a black conservative, they would have found some way to deploy me to help move that conversation just a little bit more to their evil side. Instead, I'm a fat black liberal, and they're like, well, they're like, thousands of those. We don't even need you, right? The development of our bench is so bad. So when I go back to your point, you're not wrong. Give Brian Fallon money, because it's the money that allows them to do this, right? The Federalist Society is bankrolled by the Koch brothers. Most people know that. What most people don't understand is that almost every conservative lawyer pays the VID to the Federalist Society, right? Conservative lawyers are going to give them $100 a year just because they're conservative lawyers. All of them, all the people that you like now, like George Conway. What does he do? He gives money to the goddamn FedSoc. And that's how they're able to fund and develop their bench of legal thinkers, not just on the Supreme Court, but through the entire legal system. And we don't do that. We are like, oh, ACLU, they're cool. Also, I should give some money to the ASPCA because dogs are awesome. We don't think about this, and we have to. And so that's why Democrats are bad. White men leading, and just an underdevelopment of our youth.
So I'll say something about the second part of your question, which is what could Congress do now and start thinking about. And one of the big things is that you can't actually make complicated change if you haven't done the work of figuring out how to do that in advance, vetting it, making sure it's actually viable. It's why it's harder to do things than to undo things, because it can be very challenging to actually accomplish things. And so one thing that members of the House or Senate could do right now is start putting together versions of legislation across a wide variety of court reform proposals. These could be some of the things we've talked about today. In fact, in the pre-1937 period, there were dozens and dozens of proposals in Congress on ways to reform the court and pack the court or do other things to the court. So that's one set. I think another set of things are just the ways the court operates. So, you mentioned earlier conflicts of interest and recusals. Congress has expansive authority to set rules in this area, constitutional authority. People could start working on those kinds of questions and start writing up proposed bills. That has to be vetted. There'll be lots of debate. You can have hearings on all of that. There'll be people who will come testify about them. That is the work that helps get these things socialized, done, thought through by everybody who's important, so that when there's an opportunity to pass them, those things are more viable to be passed. And so to people in Congress now, setting up the stage to put some of these things out there is exactly what they can be doing right now, and that would be a very helpful thing. And that's a full range of policies, including ones that may be more plausible or less plausible, because having more debate on this is, I think, a good thing.
Sean?
On why
Democrats suck on this and what they can do about it.
I mean, I think that there's like a really, a more structural, answer to this as well, which is that, there's a big question of allocation of talent and resources and money. And, because progressives need to achieve their policy ends through the legislative process, a lot of our young talent and money goes to how do you pass things through the legislature. And if you look at the Republican side, they're actually quite bad at this. They don't have as much talent on the legislative side, which is why every attempt to do healthcare policy has gone down in flames. Instead, the Republican Party has invested heavily in the sort of expertise around the courts because they see that as their sort of core mechanism for implementing their agenda. So, I mean, there were, as much as I want to say, it's because Cuck Schumer or something like that, the reality is, there are real structural, structural things at play here, and the right has moved first on the court, but I think that there's a lot of hope to be had in the fact that there is much more money now going into the court. There is much more young talent going into how do we address these problems and how do we move forward. So I think that they do have a first mover advantage because of some structural factors, but it is a field of play that we can catch up in.
Would anyone like to ask anybody on this panel a question? I see a hand.
So this is one of the deep tensions, both in what people want out of a Supreme Court, and there's a big debate about what the Supreme Court descriptively actually does on exactly this question. So on the one hand, many people think you want a Supreme Court to be in line with public opinion because democracy is good, and we live in a democracy, and that's what you want. So aligning with public opinion, if you're, might be upholding various statutes, right? We have Social Security. The Supreme Court upheld that in a case, the creation of Social Security. So that would be in line with public opinion. Maybe you want them to go against public opinion because there are minority groups who are being discriminated against and they lose in the political process. So there you would want the Supreme Court to be going against public opinion. And one of the big challenges is how do you decide and how do you know which kinds of things should be in the democracy category and which ones should be in the check against democracy category? Because there are lots of groups out there, some of whom you might have a fondness for and some of whom you might not have a fondness for. Economically interested groups, for example, are groups, and there's questions, should those groups be protected or not in certain categories? And that may not just be the kind of industrialists or oligarchs or whatnot, but it could even be, small farmers, small business people. Should they be protected in certain ways? And so cases come up that touch on this kind of question. I think it's a hard one for scholars and people basically debate it. I'd be curious if you guys have thoughts on it. But I think for most people in the academy, this is, maybe the central tension or one of the central tensions on the role of courts in a constitutional democracy that you spend basically all of constitutional law talking about.
I think that the Supreme Court almost only works when it's aligned broadly with public opinion and or the public doesn't care or doesn't know what's going on. And for that, I go back to something the professor was saying. It comes a little bit I'm from Queens, but like historically I'm from Haiti, that's where my ancestors are. My wife's from Zimbabwe. My mom was born in 1950 in Mississippi. You think Brown v. Board of Ed meant anything to her? Right? No, because Mississippi didn't care about Brown v. Board of Ed, and Mississippi wasn't going to let that decision happen, right? Public opinion was against the Supreme Court in Brown v. Board of Ed, and Brown v. Board of Ed didn't matter one damn to my mother when she was 4 years old when it was decided, when she was living in Mississippi. What mattered was when they sent the men with guns in. And so at some basic level, the Supreme Court cannot act unless they don't have an army, right? So either the public generally consents, like, okay, they're the court, they're legitimate, we're going to do what they say, or the public's going to say, I don't agree with you at all, bring it. And then we have to see if the other side is willing to bring it. And I bring this up because just at the moment, it's kind of flipped right now, right? So I think about Andrew Cuomo, who always seems to think that he's going to be president someday. He's never going to be president, right? But if he wanted to be president, go overturn abortion and then try to get across the GW. Okay, you're going to ban Muslims? Get all of your people out of my airport. And if you want, you bring the 51st Airborne in if you want to ban Muslims coming into JFK, right? That's the kind of response that a true Democratic leader would have right now, because that's the kind of response that George Wallace had in Mississippi when my mom was trying to go to school. So the Supreme Court, you got to remember, they are bound at some real deep level to broad consensus. The elitism that we talked about earlier, broad consensus amongst the people and amongst the elite. And if we take that from them, or if they take that from themselves, we're in a completely different kind of world. And a world that, again, conservatives know well how to exist in.
In line with public opinion on Medicare for all, out of line with public opinion on abolishing ICE.
Anyone else with questions? Some dude back there.
So at least in the scholarly world, there's a lot of academics who think that basically the courts do follow public opinion to some broad extent. And so if you have massive public support for something, the likelihood that the court will go against that is going to be relatively low. They might in some cases, but it's going to be relatively low. So the kind of strategy that you're outlining would support, has some support in that kind of literature, that's likely where the court might go. Now, the question is, would a court actually go there? And, the challenge I think that we see in the highly polarized court that we should expect going forward, or that at least it's likely to expect going forward, is that when you have people who are reasonably ideologically committed, they may be less likely to go down that road of being deferential to where majorities are. Now, another component of what and that's the threat that I think brings at least me and presumably others here today, which is that's the concern, is that that's a crisis for the court itself. It's a crisis for the country too. The other side, though, just to add to this, is both in the New Deal era and in any context going forward, a key component is also how you draft the statutes that the court has to look at. So there are ways to draft things that are more viable and less viable. There are ways to draft things that are more questionable, but there's also a savings clause. A savings clause is a fancy way of saying you have another provision in the statute that says if you, the court, finds this first provision unconstitutional, we default back to this second provision, which is designed in a slightly different way, which is probably more likely to be constitutional, right? So there are ways that you could build those kinds of things into statutes that would help solve this set of problems as well.
You got to ask yourself, what is the Federal Society screening for? Like, what makes the Federal Society say, oh, you're Supreme Court material and we're going to keep you at the circuit court, right? And it is that ideological consistency and that ability to not give a rat's ass what the people think, right? Alito's not changing his mind. He doesn't care, right? Gorsuch is the same way. We know it's not smart. We just saw Kavanaugh. It's not a smart man. That's not why he was picked. He has a partisan belief in him that isn't changing just because the will of the people is against him, right? So one of the things that, remember, the scarring moment for the conservative movement in this country is David Souter, right? He was a Republican judge, he was picked by a Republican, he was supposed to do a Republican, and he grew a damn conscience. How could we possibly let that happen? And the last generation has been avoiding a Souter, or even a Kennedy, who voted with them 90% of the time, but again, gay is kissing. What's up with that? Souter, Kennedy, if you want to go really far back, you can go all the way to Stevens. These flips have scarred conservatives, and they're determined to never let it happen again. So ideologically, I don't like these people, but they will be ideologically consistent. That's for sure.
And with that, I believe we're done.
We're all gonna die.
Thanks for coming. Thanks, Brian, for organizing. Good night.
I thank you all for coming. That was awesome. That was so awesome. We need to clip that and just pay to make people watch it in Iowa and New Hampshire and South Carolina and Nevada and make the Democratic presidential field take account of all this. The only thing I wanted to say in closing was on Monday, December 17th, we're going to be hosting a screening, an advanced screening of the RBG biopic, speaking of Avatars of Hope. Sean mentioned Avatars of Hope. On the Basis of Sex is the new major motion picture dramatically portraying the life of RBG. Comes out in theaters on December 25th. We're going to be showing it on December 17th. So come see it for free early.